this is like one of the really important questions that the court is wrestling with, because when you start thinking about cases that don't involve laws that are specifically targeted at stamping out religious practices, but you think about generally applicable laws, and then somebody says, wait, no, I don't want to comply with that generally applicable law because of my religion. Those are the hard cases. And maybe the hardest cases are when the general law that somebody is trying to say they don't have to comply with is a non-discrimination law. And so you can think about the way that these two cases have come up to the Supreme Court more recently is cases in which there's a state law that is a non-discrimination on the basis of sexual orientation or could be marital status. And there are lots of these laws out there that, sometimes referred to as public accommodation laws, that if you are offering some kind of public accommodation, whether it's a restaurant or a bakery or any other kind of generally open business, you can't discriminate on a whole bunch of listed bases, which could include, interestingly enough, religion, but also could include things like sexual orientation or race. And so these cases come up in front of the Supreme Court where somebody's asserting either a RFRA or a free speech or a free exercise claim to essentially not comply with one of those non-discrimination principles.